Hello, welcome precious viewers. This is still Gwungmijana's legal discourse, and this video is a continuation of the topic character evidence. Character evidence. In the last video, I started the discussion on another limb of character evidence, which is character evidence in criminal cases, and the discussion was also divided into two parts: evidence of the accused good character and evidence of the accused bad character. So I've ended the discussion on evidence of the accused good character in my last video on this topic. If you have not seen, you need to see it for a logical and better understanding. In this video now, I want to talk about evidence of the accused bad character. Evidence of the accused bad character. So the question here is the evidence of the accused bad character admissible? Is it admissible to give evidence of the fact that the accused is of a bad character in order to prove your case? That's the relevant question. Now, we are not also going to wander in the wilderness looking for the answer, because the principal authority here, the Evidence Act, has provided the answer as to the admissibility of the accused person a bad character. The answer has been provided for us. So let's hear from the horse's mouth as to whether or not evidence of the accused bad character is admissible. The answer to that is provided in section 82 sub 1 of the Evidence Act. Section 82 sub 1 provides the answer to us, and let's see what the section states. The section states thus: section 82, please pardon me, section 81 rather. The answer is provided in section 81 sub 1, which provides, in criminal proceedings, evidence of the fact that a defendant is of good character. No, I was correct. Section 82 sub 1, yes, I was very correct, firmly correct. Section 82 sub 1 provides, except as provided in this section, evidence of the fact that a defendant is of bad character is inadmissible in criminal proceedings. So look at the operative word, except. That word except is telling you that except it is provided that it will be admissible. That means there is exception to it. Evidence of the fact that a defendant is of bad character is inadmissible. So the answer is that it is inadmissible, subject to the exceptions provided under that section or any other section. So the general rule is that evidence of the defendant bad character is inadmissible, subject to some exceptions. So where a court admits evidence of a defendant bad character and base its conviction is its decision on such evidence. the decision will be easily upset by the appellate courts if the trial court admit evidence of the accused bad character in violation of the Evidence Act. And there's one illustrative case here, the case of Chukwueke versus the states. Chukwueke against the states illustrates that fact. In that case, evidence of the second appellant, there were two appellants, bad character, that he was disposed to the act of armed robbery, was accepted by the trial judge and also formed the basis of his conviction, of the second accused conviction. On appeal, it was held that the trial judge ought to have expunged the evidence from the record, whether or not objection is taken by the counsel to the accused, as the evidence was taken in contravention of the Evidence Act, and that was the Evidence Act cap 112 section 69 sub 1 and 2, which is now section 82. So that case was decided under the old Evidence Act, and the trial judge received evidence of the accused bad character, and it was on the basis of the evidence that he convicted the accused. On appeal, the appellate court held that even if the counsel to the accused did not object to the admissibility of the evidence, it is the duty the trial judge ought to have expunged that evidence from record and ought not to have formed his decision, based his decision on it, because it was received in violation and in breach of the Evidence Act. So you can see that except the circumstance fall under the exception provided under the Evidence Act, where the accused or where evidence of the accused bad character is received and it influenced the decision of the court, it will be, such decision will be easily upset or turned or set aside on appeal. Now, as we have seen from the provisions of section 82 sub 1, there's a proviso word which is excepts, meaning that there are exceptions to the general rule that evidence of the accused bad character is inadmissible. There are exceptions. So let's look at this exception now. The exceptions is provided in section 82 sub 2. So in section 82 sub 2, there are exceptions to the general rule. The section 82 sub 2 provided for two exceptions to the general rule that evidence of the accused bad character is inadmissible. And also, there are some exceptions provided in section 180G I to III. There are also some exceptions there. So these are the two sections that provide for exception to this general rule, although the exceptions in those two sections are similar. So we shall start with the exceptions provided under section 82 sub 2. Let's hear from section 82 sub 2. It provides the fact that a defendant is of bad character is admissible when when the bad character of the defendant is in issue, B, when the defendant has given evidence of his good character. So you can see the problem. Our law more often than not, it's not always straightforward. I will know that there is room for exception, but you'll find out that in most cases, the exceptions provided to a particular rule will be such that the rule will become almost useless. So our law always approbate and reprobate. It will blow hot and blow cold. So it has blown hot, now it is blowing cold again. It stated first that evidence of the defendant or accused bad character is inadmissible, but now under subsection 2 of section 82 is saying that it is admissible in two cases. One, when the character of when the bad character of the accused is in issue. Secondly, when the accused has given evidence of his good character. Those are the two exceptions, and let's briefly look at what these two exceptions entails. So the first one is when the bad character of the accused is in issue. Now, the question is, when can it be said that the bad character of the accused is in issue? The bad character of the accused can be said to be in issue where the bad character of the accused is an essential element of the charge of the offense for which the accused is charged. So if the element of the offense for which the accused is charged requires, one of the elements is the bad character of the accused. If it is an element, if the bad character of the accused is an essential element of the offense charge, then it is said to be an issue. That is, if proving that the accused is of bad character is one of the requirements to prove the charge, the offense before the courts, then it is an issue. Now, the next question is, how can the bad character of the accused be an element of an offense? Anyway, bad character here simply refers to previous conviction. So it is previous conviction. Bad character of the accused here refers to previous conviction. So it is previous conviction that represents the bad character of the accused here. So where the offense before the court or for which the accused is charged with require the proof of previous conviction, then the accused cannot complain. The prosecution in that case is entitled to prove his previous conviction, and by proving his previous conviction here represents the bad character of the accused. So bad character of the accused here is the same thing as previous conviction. That's why section 82 provides that whenever evidence of the bad character of the accused is admissible, that evidence of his previous conviction is also admissible. Now let's see some examples of cases where proof of previous conviction will be required. It is an element of an offense. One of the examples of offenses in which proof of previous conviction of the accused will be required is the offense of being a rogue and a vagabond under section 250 of the criminal code. So in order for the prosecution to prove the offense of being a rogue and a vagabond, that the accused is a rogue and a vagabond, it must prove that the accused has been previously convicted of a particular offense, and the offense here is the offense of being idle and disorderly. So the prosecution, in order to prove the offense of being a rogue and a vagabond, must prove, one of the elements is that the prosecution must prove that the accused has also been convicted of the offense of being idle and disorderly under section 249 of the criminal code. So by proving the previous conviction of the accused is actually in effect giving the evidence of the bad character of the accused, because it is previous conviction here is simpliciter to a bad character. Also, in proving the offense of receiving stolen property, in proving the offense of receiving stolen property, the prosecution can give evidence of the fact that the accused has been previously convicted of any offense involving fraud or dishonesty within a period of 5 years preceding the date of the present charge. So in proving the offense of receiving stolen property under section 427 of the criminal code, the prosecution is entitled to also prove that the accused are before the present trial, that within 5 years before the present trial, he has been convicted of offense involving dishonesty. So in doing so, the prosecution is giving evidence of his bad character, and bad character here represents a previous conviction. So that's one of the exceptions to the general rule that evidence of the bad character of the accused is inadmissible. Another exception is where the accused has given evidence of his good character. So if the accused give evidence of his good character, then the evidence of his bad character can be given. So the essence of giving evidence of his bad character will be to rebut the unmerited claims, his unmerited claims, which is claiming to be a person of good character. So it can be rebutted. That can be rebutted by giving evidence of his bad character. So in order to dislodge and rebut the unmerited favor which he might have before the courts. So once the accused give evidence of his good character, evidence of his bad character can also be given. And the illustrative case here is the case of Aruna against the Commissioner of Police. Aruna against the Commissioner of Police. In that case, the following evidence was given. For the second accused, a witness give evidence thus that I knew the second accused that is financially sound, and that he could not remember him getting involved in any trouble, and that his integrity is unquestionable. So that is the evidence given by a witness in favor of the second accused, and the court held that the evidence was evidence of good character, by which evidence of bad character may be admissible. So since the second accused has given evidence of his good character, the court held that in that case evidence of his good character is admissible because he has given evidence of his good character. So those are the two exceptions provided under sections 82 sub 2. Another exception is provided under section 80 paragraph G I to I. There's 3. So let's look at the exceptions provided under that section, section 180G I to III. There are other exceptions to the general rule there. So section 80G further protected the accused. There are some the accused is further protected by this section, in that there are some questions that the accused cannot be asked by virtue of this section. Even if he is asked, he is not bound to answer those questions. Then you cannot cross-examine him as to certain facts by virtue of that sections. Section 180G. Let's hear what the section states. It states as follows: a person charged and called as a witness in pursuant of this section shall not be asked, and if asked, shall not be required to answer any question tending to show that he has committed or been convicted of or been charged with any offense other than that with which is then charged, or is of bad character, unless then the section further provide for exception. So the first part now is showing some questions that the accused cannot be asked. However, there is an exception to that provision. There is exception when the accused can then be asked, can then be cross-examined as to in respect of those matters stated in paragraph G. Now let's actually apply the questions prohibited by virtue of section 180G. The following questions are not allowed. You cannot cross-examine the accused in respect of these matters. You cannot also, even if you ask him question in respect of this matter, is not bound to answer. Take note that the accused is a competent witness but not a compellable witness. That is, the accused can give evidence, can be a witness in his own case. He can give evidence, but you cannot compel him. He can do that by his own application. So where the accused is testifying in his own case, this section 180G is saying that you cannot ask him the following question. And these are the questions. 1. Question tending to show that he has committed an offense other than the one for which he is then charged. 2. Question tending to show that he has been charged with any other offense other than the one for which he is then charged. 3. Question tending to show that he has been convicted of any other offense other than that which is then a charge. Then 4. Question tending to show that he is of bad character. So all these questions you cannot ask the accused person. That is, you cannot cross-examine him in order to show all of this. However, there are now circumstances provided by the same section exception when you can ask him any question tending to show that he has committed another offense other than the one before the court, or tending to show that he has been charged with any other offense, or that he has been convicted, or that is of bad character. Under the exception, you cannot ask him. Now, let's look at the phrase tending to show. The first part said that question tending to show that he has committed an offense. So, what does this phrase tending to show means? The phrase tending to show means tending to reveal for the first time rather than prove. So, tending to show means tending to reveal for the first time, to disclose, to unveil for the first time, and not tending to prove. Thus, if the evidence of the conduct had been given by the accused himself, any question in that regard cannot be said to be one tending to show. So this the law is that you cannot ask the accused any question tending to show some things, and tending to show here means tending to reveal for the first time. Now, if it is the accused that mention all these facts, if it is mentioned by the accused himself, then if he's cross-examined or ask question in relation to that, it cannot be said to be tending to reveal, because he's the one that revealed the fact by himself. And that's what they call held in Jones versus DPP, where the accused disclosed in his examination in chief that he had previously been in trouble with the police in connection with an earlier conviction for another offense, and the prosecution cross-examined him on that. It was held that the cross-examination was not one tending to show that the accused had been previously charged or convicted. Recall that under section 180J, you cannot ask or cross-examine the accused on any question tending to show that he has been previously charged or he has been previously convicted. But we are attempting the definition of tending to show here. That tending to show means tending to reveal for the first time. And as such, if it is the accused that raised the issue himself and he was cross-examined on it, then it cannot be said to be tending to show or tending to reveal, because is the one that actually disclosed it. That was what happened in Jones versus DPP. Now, let's look at some illustrative case on the prohibited question. For instance, question tending to show that he has committed an offense other than the one for which he was charged. Recall that section 180G prohibits you from cross-examining the accused on or asking him question that is tending to show that he has been charged before other than the offense for which is presently standing a trial. And one illustrative case there is the case of Sitland versus DPP. In that case, under cross-examination, the prosecution asked the accused if he had not been previously suspected of having committed an offense. There's the offense of surgery. The question was held to be inadmissible as it tends to show that the accused had committed or had been charged for an offense other than the one at hand. So you cannot ask the accused any question that will tend to show that he has been charged or he has been convicted for any other offense. Otherwise, it will be inadmissible unless it falls under the provided exception, because you trying to ask the accused such question in order to reveal that he has previously been charged or convicted is in effect trying to show that the accused is of bad character. Then illustrative case on question tending to show that he has been charged. So another prohibited question is question tending to show that he has been charged. Under this heading, question about the accused offense in which the accused was charged but acquitted is also prohibited. So by this rule too, even if the accused was charged but acquitted, you cannot also ask him a question on that. And we have some illustrative case here. We have Maxwell versus DPP. There, in that case, the prosecution cross-examined the accused in respect of a similar charge for which he was indicted but acquitted. It was held that the question was irrelevant. So the prosecution now asks the accused question relating to a charge that was similar to the one that it was a standing trial. The court held that it was irrelevant because it was tending to show that the accused was previously charged. Also in Purple Lab against COP, it was stated that question cannot be asked of charge preferred against the accused but later abandoned. Also, we have the case of R versus Coca. In that case, the accused was cross-examined about an earlier offense similar to the one for which he was facing trial. It was held that the cross-examination was wrongly allowed. So all those questions prohibited by section 180G, you may wish to see the question, the section for clarity. You cannot ask the accused, otherwise it will be inadmissible. However, there are some exceptions provided by that section when the accused can then be cross-examined on or ask questions tending to show that he has been charged for another offense other than the one for which is presently standing trial, or tending to show that he has been convicted of another offense, or tending to show that it's of bad character. When is these questions allowed? This question is allowed under the exceptions provided by virtue of that section 180G, 180G I. So the exceptions are provided in I to III, in I to III. So let's see the exceptions provided there. So it provides unless prove that he has committed or been convicted of such other offense is admissible evidence to show that he is guilty of the offense for which he is then charged. So another exception is 180 GII. The general rule is that you cannot ask the accused any question tending to show that he has been previously convicted or charged, or that is of bad character under section 180G. That's the general. But paragraph I to III is providing exception when you cannot ask him those questions which tend to show that it's of bad character or he has been previously convicted or charged for another offense other than the one for which is standing a trial. So another exception is provided under 180G II, 180G, and the exception provided there is that let's not read the section, but let me draw out the important thing there. So the point there is that if the accused or his legal practitioner asks question of the witnesses for the prosecution with a view to establish his own good character. So if the accused asks question of the prosecution with a view to establish his good character, if the accused is trying to ask question in order to establish that it's of good character, then he has lost the protection. You cannot ask him any question tending to show that is of bad character, or tending to show that he has previously been convicted or he has previously been charged for another offense. Then secondly, under that paragraph 180 GIII, if the accused has given evidence apart from asking question in order to establish his good character, also if he has given evidence of his good character. So this exception now is also similar to that provided in section 82. So the same thing now, if the accused give evidence of his good character, then you can cross-examine him in order to show that he's of bad character, in order to dislodge, to refute the unmerited favor he wants to have before the court. So if the accused give evidence of his good character, then you can ask him those prohibited questions. And the illustrative case here is Arrow versus Samuel. Arrow versus Samuel. In Arrow versus Samuel, the accused was charged with stealing a camera which was found in his possession some weeks after the alleged thefts. The accused gave evidence that he intended to return the camera and that on 2 occasions in the past he found properties belonging to other persons and returned them to the owners. In effect, the accused was claiming to be a good person, giving evidence of his good character. Consequently, the prosecution was allowed to rebut his claim by cross-examining him as to his previous conviction. So you can see where how the accused here lost his protection. Otherwise, you cannot ask the accused any question tending to show that he has been previously convicted. But where he give evidence of his good character, then you can ask him such question in order to rebut his claim. And that's what the case of R versus Samuel illustrates. Another limb or exception under that GIII is that if the nature or the conduct of the defense is such as to involve imputations of the prosecutor or witnesses for the prosecution. So there's another case or circumstance where the accused will lose the protection and it can be asked those prohibited questions if the nature or the conduct of the defense is such as to involve imputations of the prosecutor or the witnesses for the prosecution. If the way the defense is being conducted involve imputation of the prosecutor is imputed, or the witnesses for the prosecution there is imputation on them, then the accused lost protection and can be asked those prohibited questions. Then when is imputation said to be made? According to the court in Selby versus DPP, where this is where imputation are cast on the character of the prosecutor or his witnesses to show their unreliability. And when casting of such imputation is necessary for the accused to establish his defense. Imputation here has to do with ascribing one wrongdoing or another to the prosecutor or his witnesses. So what this exception is actually saying, as embedded in section 180G III, is that if the accused now is imputing the prosecutor or his witnesses, trying to ascribe one wrongdoing to them, saying that, oh, this witness witness for the prosecution has done this or has done that, as in fact the witness was bribed by the police. There's imputation that it was bribed to come and testify, or that for instance, if a member of the police force is also a prosecution for a witness for the prosecution, and the accused is making imputation on the police officer that it was maybe the officer was also bribed, or that he induced the defendant to make a confessional statement, that he induced the defendant to make a confessional statement. You can say those are imputation, trying to ascribe any wrong character, any wrongdoing to the prosecution witnesses or the prosecutor himself. In that case now, if that is done, then the accused has lost the protection. It can be asked question tending to show that he is of bad character, or that he has been convicted of another offense, or that is he has been charged with another offense. Then the final exception too is 180G III. There is where the accused give evidence against a co-accused. So if the accused give evidence against a co-accused, then that co-accused can ask him question tending to show that he's of bad character or that he has been previously convicted. That is, he can cross-examine him on that matter. There is, yeah, if the accused is charged alongside other person or person, and they are being tried jointly, on the same offense, and the accused, one of the accused, gave evidence against his co-accused, maybe implicating evidence against his co-accused. In that case, now that co-accused can ask him question tending to show that he has been previously charged for another offense or that is of bad character once he gave evidence against his co-accused. And the condition, one important condition, is that they must be charged for the same, underline the word the same. It must be the same offense and in the same trial. If it is a different offense, even though it is in the same trial, then the exception does not apply. So yeah, if guard and long are charged for the same offense of stealing and they are tried jointly, then guard gave evidence against long. Long now is a co-accused to guard. Guard now gave evidence against long that perhaps it was long that he induced him, or he actually, deceived him into committing the crime. In that case, he's giving evidence against his co-accused long. Now, long will be allowed to cross-examine guard as to the fact that he has previously been convicted, or as to the fact that he's of bad character, because he's giving evidence against his co-accused, who is long in this circumstance. So once you give evidence against your co-accused, then your co-accused can ask you those prohibited questions. And we have one illustrative case here, the case of Anyanwu versus the states, or Anyanwu versus Queen. Illustrate that part. Note that the question here can be asked by the accused or his counsel. So in Anyanwu now versus state or Queen, in that case, a co-accused gave evidence against the appellants. Another accused person gave evidence against the appellant. In this case, the appellant now is a co-accused to that accused. And the evidence was accepted by the trial judge. And the trial judge formed his decision based on that evidence and convicted the appellant. Counsel for the appellant at the trial asked for permission to put questions as to previous conviction and bad character of the co-accused who gave evidence against the appellant, which the trial judge disallowed. So a co-accused now, somebody that was charged with the accused for the same offense, gave evidence against the appellant, and his counsel wanted to cross-examine that the other accused that gave evidence against the appellant as to his previous conviction and bad character. But the trial judge rejected, did not allow his counsel to do so on appeal. That was one of the grounds of appeal, that the trial judge ought to have allowed the counsel to cross-examine the co-accused who gave evidence against the appellant. So on appeal, the appeal was allowed and the conviction, and it was held that the trial judge, where a co-accused has given evidence, an accused has given evidence against his co-accused, that he has lost the protection, and the trial judge does not have any discretion to disallow that person from being cross-examined, that he must be cross-examined as to whether his previous conviction or bad character that the right to cross-examination is a matter of rights. It's a matter of right since he has given evidence against his co-accused that it was held that the trial judge was in error for not allowing the counsel for the appellant to cross-examine the co-accused since he gave evidence against the appellant. So from all that we have been saying, from the combined effect of sections 82 sub 2 and section 80 G I to II, there are actually 4 major exceptions to the general rule that you cannot give evidence of the defendant bad character. That's the general rule. But there are exceptions under section 82 sub 2 and under section 180 G I to II. And a combination of that section, the exceptions are actually where the bad character of the accused is a fact in issue, then evidence of his bad character, which in this case is a proof of previous conviction, can be given. Another exception is where the accused give evidence of his good character. Another exception is where the accused made imputation of the prosecutor or the witnesses of the prosecutor. And finally, where the accused give evidence against his co-accused. Then it can be asked those prohibited questions. So there's basically that on character evidence in criminal proceeding. Finally, one of the reasons why parties resort to character evidence is to impeach the credibility of witnesses, to impeach the credibility of the witnesses. That's one of the reasons why parties resort to character evidence. So reasons for character evidence is to impeach the credibility of witnesses. Then it can also be used for substantive purpose. That is where it is a fact in issue. Then character evidence can be relied upon. That is where it is also necessary to prove a particular case or a particular offense. Then character evidence can be relied upon. In that case, it is referred to as being used for substantive purpose. So that's the end on character evidence. Please don't forget to subscribe if you have not.